Advocates have expressed disappointment following the Ontario Superior Court's decision last week to dismiss a charter challenge, which was launched by sex worker advocacy groups. Now, the court ruled that Canada's laws on sex work are constitutional and do not violate charter rights. Justice Robert Goldstein's decision outlined the Protection of Communities and Exploited Persons Act. It noted that it balances the prohibition of the most exploitative aspects of the sex trade with protections for sex workers. The Canadian Alliance for Sex Work Law Reform had argued in court last fall that the laws fostered stigma, invited violence, and prevented sex workers from obtaining meaningful consent. Well, joining us now is Ms. Jenn Clamen, National Coordinator of the Canadian Alliance of Sex Work Law Reform. Ms. Clamen, thank you again for your time today.
Thank you.
And for those unfamiliar, can you give our viewers some perspective on the current laws around sex in Canada and how they're affecting sex workers in our country?
The PCPA laws, the sex work laws, for the first time made sex work illegal in Canada, which has really exacerbated a lot of the harms that come with the constant surveillance and presence of law enforcement in the lives of sex workers, particularly marginalized sex workers. So sex workers are forced to avoid detection at all costs because the industry is criminalized. And so that it makes it so that sex workers are experiencing increased isolation, lack of supports, and lack of capacity to build community for safety supports.
And can you walk us through this charter challenge and what exactly your organization is advocating for?
So our organization, along with 5 individual applicants, are advocating to strike down the laws or the provisions within the PCPA, arguing that they infringe on sex workers' rights to bodily autonomy, security and safety, and equality. By no means is the case arguing in any way for a constitutional right to sell sexual services. It's arguing for the protection of basic rights and freedoms.
All right, ma'am. And turning to last week's ruling, you were quoted telling CBC Toronto that there's a lot of incorrect information that went into this decision. Can you tell us a little bit more about this incorrect information?
I can name a few ways in which the decision was incorrect, quote unquote, or where the court got it wrong. One of those ways is the dismissal, complete dismissal, that saying that sex workers don't actually know how the law works. And so all the evidence put forward by sex workers to suggest that sex workers are experiencing harm because of criminalization, it's because sex workers don't know what the law actually is or what the law does, which is really dismissive in a context where sex workers live under the criminalization regime every day. It also, fails to recognize or lacks empirical evidence to demonstrate the relationship between stigma and violence. And we know beyond sex working communities that relationship has been demonstrated time and time again. We only need to look to the way trans communities are targeted for violence today based on the stigma against trans communities. Other ways that they got it wrong was just to sort of ignore a lot of the evidence, actually just completely pretend that it wasn't there. A lot of the evidence from sex workers, particularly Black and migrant sex workers, that demonstrate how sex workers still are being arrested and experience a lot of the effects of criminalization.
All right, ma'am. If we look at some of these opposing concerns here, particularly by Parents Against Child Trafficking, in this case, they point to sex work being a violent industry that is extremely exploitative. So how would the potential decriminalization of sex work or regulation of sex work impact the issue of sex trafficking in Canada? And what evidence can you point to?
Well, I would first say that there hasn't been any evidence to demonstrate that sex for money is exploitation. And that's just an ideology that's been accepted as fact by the court and not necessarily demonstrated through any empirical evidence. So I would start there. But secondly, we know that in any industry, and most industries do have labor exploitations and abuses. And that's actually why sex workers started organizing about 60 years ago, was to address those exploitations and to address that violence. And one of the ways that we propose to address that violence in other industries is not to abolish the industry itself. So we don't abolish the agricultural industry. We don't abolish live-in caregivers. We change working conditions so that workers have access to labor laws and labor protections. And so decriminalization would allow for that access because it would recognize sex work as labor, and it would make it so that cases of exploitation are easier to identify rather than lumping the entire industry into a category of exploitation where criminalization allows that exploitation to flourish.
All right, ma'am, we've got a quick 30 seconds left here, but what would the ideal system in Canada look like?
It would be decriminalization. We would not have a sex industry that's regulated by criminal law, but it might be regulated by labor standards, occupational health and safety standards. We would have issues around poverty and economic advancement be addressed for communities that don't have those opportunities. But criminal law is just another tool that's used to marginalize communities, particularly those on the street and Indigenous communities and Black communities. So we would not have a sex industry regulated by criminal code, but rather by other mechanisms.
All right, Ms. Clamen, thank you again for your time today.
Thank you.
We'll be right back.